good to be back. I'm from Windsor. I had my first large-scale dominatrix and escorts operations here. I recently placed my papers in the University of Windsor archives. Also, this is the third time I've spoken at the University of Windsor. The first time I came here with Val Scott and Alan Young. We spoke about the Charter Challenge and related things. I was here 3 years ago, 1 month after the Supreme Court struck down the sex trade laws, and I spoke about that. Today, I'm going to speak about 4 things. First, the greatest joy, which everyone knows is sex. Second, the worst glue, which everyone knows is being a lawyer. Third, my insider's perspective on Bedford versus Canada. Finally, some thoughts about the sex trade issues many of you will be participating in when you graduate. Sex. Sex is very popular. Men are conditioned to lust after women, and women are conditioned to want to be lusted after. Yet women don't want to be harassed. Even before the current flood of women coming out in 2017 to complain of unwanted attention or other inappropriate behavior, men found the process of dating or courting women to be very intimidating. Look at the messages women send out. Message: women want to be chased. Message: women want a commitment. Message: women like sensitive men. Message: women like aggressive men. Message: women want a man who spends time with his wife and children. Message: women like successful men. Message: women want to be stay-at-home mothers. Message: women want a career. Message: women do not like men who dominate them. Message: 50 Shades of Grey sold millions. Message: women want men to be intimate with them. Message: when men disclose their true wants, they are usually seen as wimps or perverts. So, even men who are presentable, sociable, gainfully employed, and so forth, are usually intimidated by dating and afraid of commitment. Then, of course, there are men who may be poor, ugly, shy, inarticulate, or disabled. What do they do for companionship? Enter the sex trade. I have been in the sex trade for most of my life. And here are some things I've come to believe. First, most men want companionship where they don't have to worry about doing and saying the right things. Example, a man's blood pressure shoots up when he has to get a woman a gift. Men hate sending cards and flowers. Men are afraid to flatter women because of fear of saying the wrong things. If you gals run into a guy who's good at these things, odds are he's a con man, or he found a woman to coach him in dealing with you, like his mama. Sex workers commonly tell of clients who pay and are content to do nothing other than look at and talk to her, clothes on. So great is the relief of not having to worry about what to say or do. Then, of course, there are clients who want physical companionship, where they can touch and be touched. Again, without worrying about whether they are doing or saying the right things. Despite all this, men seek intimacy, but not with their regular partner. One of the reasons men hate communicating their thoughts is because they may be thinking about other women, or about doing things most people might laugh at, or worse. However, when a man tells a woman he hires what he wants to do, really wants to do, and she accepts it and makes it happen, he is rewarded for self-disclosure instead of punished. They do not have to share any other part of their lives with these women. Nobody has to know he likes wearing women's clothes or be chained and whipped. But just disclosing it to someone and perhaps acting it out is like therapy. It is also escapist recreation. Dreams are coming true. Also, women are beginning to pay men to be the man of their dreams for a time. The point is, there is a market for the purchase and sale of sex and fantasy role play. It's significant and not going away. Most of the business is repeat business. Most of the business is indoors. The authorities have limited resources to sweep clients and rarely do so indoors. Enforcement of the current law is negligible. Now, on to the motivations of the sex trade worker. Well, why does anyone do anything? Usually it's because they need an income or more income. How many women want to clean toilets for a living? How many want to work in a factory for low pay? How many want to serve in the armed forces and get sexually harassed and persecuted if they complain about it? Few people earn the living the way they want to. Most people follow the money, such as hours that are manageable or locations that are accessible. Sex workers can make good money, more than most junior lawyers. They may only need a few hours a month for the administrative parts of the job, if that. And seeing a client once a week might provide enough income to get by. It may not be the only thing you do for money. Some students work their way through college in whole or part, sometimes having only one client or a few. They may work for agencies or others are in business for themselves. Some girls at this university reportedly have sugar daddies. If the government really wanted to reduce sex work among those less inclined to it, the best way is to invest in higher welfare for single mothers, affordable daycare, the collection of child support from deadbeat dads, lower tuition, better protection for women from sexual harassment in the workplace, more enforcement of the laws that prevent human trafficking, like immigration laws, and repealing laws that encourage it, like the current law against the sex trade, Bill C-36. So, now that you know all about sex and the sex trade, I can take over from your professors and let you in on a few things about the greatest gloom. So, you want to be a lawyer. Well, there are some things about the law and the legal profession that your professors may have overlooked. And pay attention, this will be on the exam. Let's start with a few thoughts about the sex trade. The law is often, if not usually, a minor factor, repeat, minor factor in what happens out there. About 20% of Canada's economy is underground. Much above ground activity is fraudulent, with those breaking the law often not even knowing they are doing so. Most men buying sex today don't know what the law is on that, really. Many who run massage parlors or escort services don't know. There are sometimes illegal immigrants who are grateful for money to send home. They and their employers may view being nabbed by the cops as a minor interruption in their business. Clients who get nabbed usually just look for the path of least cost and least notoriety. That being said, clients very rarely get nabbed. That's mainly because so much of their business or buying is repeat business. The lack of enforcement of the sex trade is also because the authorities, even before they consider going after the sex trade, already have overcrowded courts and jails. Police forces are very busy, and many officers are burned out from other pressures. So they have to prioritize. That is in part why few women and few men are being charged. However, there are massive numbers of transactions out there which relate to the sex trade. Proper business management is required for licensing, tax planning, health and safety, labor relations, advertising, leases, and so on. So, think of future clients associated with the sex trade as business people. The trend is even towards the sex trade becoming mainstream and corporate. Now, on to the lawyers. I'd like to share some of my thoughts about lawyers with you. This may even be on the exam. I am an expert on lawyers, judges, and, get this, law professors. I have flogged them, diapered them, made some of them sissy maids, hired them, fired them, and made some well known. Some have become judges. I've had about 20 lawyers represent me in court or do other legal work for me. They were either not paid or paid by someone other than me. I was not a very representative client, but I was a client. When you graduate, you will encounter clients. Some of them will not be a dominatrix. There are many types of clients. Some clients are businesses. Some, like banks, employ lawyers. And some, of course, are individuals. All clients have something to say about lawyers and the law, and not just in lawyer jokes. For example, what makes a good lawyer or a bad lawyer? I think most lawyers are smart, knowledgeable, and good talkers. But often it is only when they have other lawyers or judges ready to criticize them that they produce for you. When clients deal with their lawyers, the adversary isn't there watching. It can be a nightmare. They avoid and bully clients as much as they serve them. So the presence of an adversary or another lawyer working with them on a case will help keep them up to the mark. Another option is to have someone who is skilled at dealing with lawyers assist clients in dealing with their lawyer. This, as much as anything, has enabled me to fight over the years. I did not have the knowledge or the confidence to hire and fire lawyers with authority, the way some of my supporters did and do. Lawyers sometimes hate dealing with the middle people. Fire those lawyers. Clients need representatives in dealing with their lawyers more than they need lawyers dealing with their adversaries. Frequency of communication is key, and one-man bands don't cut it. Now, in large mid-sized law firms, the juniors and case managers fill the role of middle person sometimes. They make sure communication is timely, calls are returned, and things are explained patiently. So clients, and lawyers for that matter, should think team. Not just about the main lawyer. A good law practice is more important than a good lawyer. Good lawyers collaborate well and delegate well. Having a great legal mind often has little to do with being a good lawyer. There's also one more thing for you women law students to consider. Some of you may be in the sex trade now. Some of you at this university reportedly have sugar daddies. You do it by choice. And I think law school is an excellent training ground for becoming a dominatrix. Girls, think of debating some guy who's gagged and bound. Think of being prosecutor, judge, jury, and jailer over some jerk who really deserves punishment and then punishing him. And think of getting paid for it, plus tax. Or you can do it as a class project. Most of you know me from the Supreme Court decision in Bedford versus Canada in 2013. The challenge to 3 of Canada's laws targeting the sex trade was filed in 2007. A decision given in 2010 in Superior Court, early in 2013 in the Ontario Court of Appeal, and late in 2013 in the Supreme Court. You may have studied the decision and the issues. Rather than tell you what you probably know already, I want to go into some considerations that may not have come to your attention. But before I do, as always, I want to express praise and gratitude to my fellow plaintiffs, Val Scott and Amy Leibovich. They, more than me, have been and are dedicated ongoing activists and have been recognized as such. Kudos as well to Professor Young and his team of lawyers and law students, and to the other volunteers. So, now some considerations. The first consideration is someone who graduated from this law school. I'm talking about former Justice Minister Rob Nicholson. I want to tell you about one single moment in his life. I think it was a defining moment for both him and Canada. In March 2013, the Ontario Court of Appeal basically upheld Justice Himmel's 2010 decision striking down the key laws against prostitution. A few weeks later, Nicholson stood up in the House of Commons and said something to the effect that he was pleased to say that his government would appeal to the Supreme Court and would not discuss the case until the court had ruled. Of course, that made the matter go away for about a year. Now let me tell you why I think that was a defining moment. Reason number 1. I think he knew there were merits to what Himmel's decision contained. Merits that he could have acted upon immediately. Like allowing sex workers to hire off-duty police as security or work in groups from fixed locations. Or support spouses and children who live with them. I think he knew the laws were void for vagueness and could have made them clearer and fairer. I think he knew that other laws could, as Himmel said, be used to control the worst aspects of the sex trade. And I think he knew the laws themselves created dangers for women and resulted in deaths. I think he knew all this, yet with pleasure, as he put it. He appealed the whole package and did nothing. Reason number 2. He knew, or should have known, that it was against every principle his party stood for to lump consenting, harmless adult behavior in private, like women paying younger men for sex, men keeping women, and women like me who enjoy punishing and humiliating men who pay me to do it, in with trafficked or abused women. That is not allowing for individual autonomy and responsibility for one's own decisions. I think he knew all this, yet with pleasure, as he put it, he appealed. Reason number 3. If I am wrong about the first 2 reasons, it was definitely an even more defining moment. Perhaps he actually believed his stated position that the laws were constitutional and that no charges were needed. If that's true, if he believed that nothing being said by all the judges, the experts, the sex workers, and others had any merit at all, if he believed all that, he's a mental defective. So, my friends, it was a defining moment because it was then and there that the Justice Minister proved himself and his government to be either liars or mental defectives. I'll compromise and say they were both. 3 levels of court are there to show it. But wait, it gets worse. If instead of appealing, he had just brought in the new laws we have now, there would have been no Supreme Court decision. The Supreme Court, a 15-0 decision. Decision authored by the Chief Justice. You students and you professors have a massive interest in this matter simply because it was a unanimous Supreme Court decision, laying out the grounds for new laws to stand up. The Supreme Court! What would be your thinking if they had kept this out of the Supreme Court? Now again, what law school did Nicholson go to? So, why did it go to the Supreme Court at all? I think it's partly because Nicholson and Harper didn't think of any of this, or listen to people who did. The temptation of another year with an excuse not to comment was too great. Also too great was doing what their base of voters and donors would want. That meant not admitting defeat. It meant fighting pointlessly against us and Judge Himmel and the Ontario Court of Appeal with taxpayers' money. Now, on to what it took to mount the challenge. Professor Young told the Senate committee looking into C-36 that at full freight, the case would have cost our side alone over $1 million. And probably cost the government that much a number of times over. Perhaps I can give you some insight into why. After much consideration, I think the best way to do this is to tell you year by year what had to be done. And remember, this was just on our side. (2002 to 2003). My legal battles had ended and my second house was closed. I was out of the public eye. I was going into chemotherapy for hepatitis C, and essentially from then on have been disabled. I occupied my time when not doing essential errands and appointments on writing projects, painting, and doing some clerical work at home for a small business. Alan Young told me he was going to do what he ended up doing, meaning striking down the prostitution laws in court. He wanted me to be one of the plaintiffs. People around me were divided, but the decision to support my participation was mainly driven by the fact that my chemotherapy would be done in time by the time anything substantive occurred. He also wanted Val Scott, a long-time and articulate activist for reform of the sex trade laws. Finally, Amy Leibovich, came forward. Her importance was that, unlike Val and me, she was still active in the trade. Indeed, her presence was most important from a technical standpoint because her standing in the case was not subject to possible challenge on grounds that she was not being impacted by the laws. Others from the sex trade who were willing to be plaintiffs were asked by Alan to be expert witnesses. So, in getting all this in order, how many billable legal and administrative hours are we at? Remember, the Supreme Court decision was late in 2013. 2004 to 2006. I did little in the next couple of years, but much more in 2006. Once Alan had his plaintiffs lined up, he organized students and other lawyers who were to participate in various aspects of the initiative, such as keeping correspondence organized, drafting and obtaining finalized affidavits, identifying and locating expert evidence and expert witnesses, interviewing and hiring a legal team, arranging and executing the logistics of transportation and accommodating them, preparing factums, preparing for examinations and cross-examinations, preparing courtroom appearances, scheduling and rescheduling as required, and of course obtaining the financing for all the above that had to be paid, such as travel costs. I recall that Val, Amy, and I spent many hours at my place. Our focus was on the logistics of travel and accommodation of the experts. I put a lot of my correspondence and my papers in the archives at this university. And it shows how many things needed attending to. Just on our side, the law students and lawyers dealt with assisting the lawyers in assembling the expert evidence and preparing the experts for their appearances. The federal and Ontario justice officials had to undertake similar challenges, but their work was all paid work, and it seemed to us they had too many lawyers and summer student helpers. Fiscal conservatives, my ass. 2007. That year saw the acceleration of the activities of 2006. Plus, we had a press conference to announce the challenge. And then, as the final documents were filed and the first hearings were about to get underway, the issue got a little mainstream publicity. Where are we at in billable hours now? What about the value of time spent by volunteers? There were volunteer groups on our side and the other side, such as real women who sought standing and made submissions. 2008, for me, was the year mainly taken up by the movement of experts from out of town and their appearances. I attended about 2/3 of the sessions in which evidence was examined. I would say there were about 50 full days in total, meaning days where the hearings were not public, but there were transcripts. The purpose of the meeting was for the experts who had submitted evidence to be cross-examined. Plaintiffs were also cross-examined as to their affidavits. When my time came, arrangements were made to have the media interview me outside the meeting room in the federal government building where most of the sessions were held. Then they asked to sit in on the testimony. Alan had nothing to do with it, but the idea was to screw up their cross-examination timing and send a message that they were being watched. The reason it screwed up their timing was that counsel had to meet to figure out how to deal with reporters, who up until now were absent. It was Alan, in fact, who wanted the sessions to remain private because the personal lives of the witnesses was so exposed. The whole thing got some press. More billable hours too, paid and unpaid. 2009. The first half of 2009 was a continuation of 2008. The hearings wrapped up, and after the summer, the case was moved into open court. I will speak briefly about the official hearings and then about things that are likely new to you, even those of you who have studied the case. The judge in the Ontario Superior Court, Susan Himmel, had reviewed tens of thousands of pages of factums, affidavits, expert evidence, and its testing in cross-examinations via transcripts. She heard submissions from the lawyers of the plaintiffs, governments, and interveners. She rejected applications for intervener status from 3 groups, basically Christian groups who opposed the challenge. They appealed that decision, and the Ontario Court of Appeal overturned Himmel's decision. So they got media as well and contributed their moral views, but nothing of substance. There were 9 days in court, and the billable hours meter blew up. I came to court the first day dressed in my leather suit, boots, and carrying a riding crop. Val and I made a point of posing for the media. I was told by my advisor for the day, a supporter savvy in these things, to walk up and down the street, a bit with Val, keeping the riding crop near my face and carrying a light briefcase under my arm. Black leather briefcase, of course. The key was to keep these 2 props near my face so they would appear in photos. I had to try to remember to face the sun so the images would be better. And I was told to be sure they got pictures with my sunglasses on as well, and of me talking on the phone. I remembered most of the advice, and it paid off. In fact, one of the guys in the media pack was that supporter. When I looked at him, he would remind me of these things as discreetly as possible. I have to confess to you that I often found the public hearings dull. The technical references and quibbling over words seemed stupid at times, at least to me. However, Alan's concluding speech had me in tears. I only attended about half the hearings as my health was continuing to deteriorate. 2010. The year 2010 was quiet up until the end of September. The judges used all the allotted 12 months to deliberate the 25,000 pages and issued a 131-page decision in our favor. I was dressed in my leather suit for the press conference just after the release. We really did not know what to expect, despite the clear indicators that our case was better. The uncertainty was in part Alan's caution about giving false hopes to clients. My uncertainty was in part from being a victim of blatant judicial corruption and incompetence in the past. I did not have anything prepared in the way of a speech. A couple of one-liners were in my back pocket if we won or lost. I was going to let Val and Nikki Thomas, both experienced communicators, do most of the talking. Nikki Thomas was the executive director of the Sex Professionals of Canada, and Val, a post Val had previously held. You can see me with both of them in pictures on the internet. When we found out we won, my supporters sent out press releases. I called them with interview requests I received, and they handed the scheduling and my movements. The sessions I had watched during the case, and what I had said before, and what Val, Nikki, and Alan said in the press conference, provided me with the words to say to reporters in the days after the release. At the press conference, I remember some of the tips about providing the media with content. 2011 and 2012. There were hearings about how long the stay of the Himmel decision would last. The decision of the courts was that the old laws would remain at least until the Court of Appeal had ruled on the lower court decision. I appeared at the courthouse at strategic times. gave our case in the media personally, and of course made sure the media had good images. I was advised by one key supporter to beg reporters to ask the Prime Minister a question from me. One of them did. His response was on television. He said he had never been asked to respond to a dominatrix before and did not know why or who I was, and did not know who I was. The reporters laughed. He was either lying or the only one there who didn't know who I was. What an idiot. However, unlike Nicholson, he did not go to law school here. The appeal was heard at the Ontario Court of Appeal in the summer of 2012, and their decision came out almost a year later. There was a lot of publicity and discussion in the media during the hearings, which lasted 5 days in the Court of Appeal. There were overflow rooms with screens. We were mobbed by reporters the 3 days I was there. So, to recap, September 2010, Himmel decision. September 2012, Ontario Court of Appeal holds week of hearings. March 2013, Ontario Court of Appeal hands down its decision. 2013, when the Ontario Court of Appeal decision came out in March, we did another press conference and all that. Basically, we won. As expected, it was going to the Supreme Court. We expected the hearings to be held in the summer or fall, and a decision in the new year, meaning sometime in 2014. Of course, the lawyers had to prepare their factums and books of authorities. If you look at what was filed with the Supreme Court, along with what their preceding courts had, which was also filed in the Supreme Court, each judge had about 30,000 pages dumped on their desks. I knew we would win. There was no way Beverly McLaughlin would allow anything else. A sex worker in Ottawa who had a clientele in a position to know told me on good authority that there was no substantive argument among the judges against what Himmel had wrote. I did not share those reports with Alan or anyone else. I attended a Red Umbrella rally in Toronto in the summer, the week the case was heard at the Supreme Court. The rally was one of many across the nation where sex workers and supporters marched in support of what we were fighting for. Then I went to Ottawa to attend the rally at the Supreme Court the day the case was heard. Our opponents were there too. The reporters said they had never seen anything like it. On decision day, we all went to the court in Ottawa for the release. When I found out we won big, I cried, dried my eyes, had a quick phone call to my off-site coach for the day, and did the interviews. The coach told me at all costs was to get in the joke that the Prime Minister had offered to appoint me to the Senate as a government whip. The media ate it up. The Senate at times was scandalized for a number of things. I looked and sounded like a winner, not a victim. This gave our cause credibility. So I think you can appreciate that a charter challenge is not simple, easy, cheap, or short-term undertaking. Remember also that British Columbia lawyer Katrina Pacey led a challenge to the laws, which was before the courts and would have been heard if ours had not succeeded. Here are some takeaways from my experience in Bedford versus Canada. One is that it is understandable that there are so few charter challenges. It just isn't worth it for most people. Law schools, however, can make a difference. Alan Young's initiative on the wrongfully convicted, abortion access, medical marijuana, and my matters come to mind. Another takeaway is that new laws, to avoid the flaws of the old ones, need to benefit from the evidence and decisions that our challenge made available. The previous federal government, who were voted out of office in 2015, did not make use of those resources. I want to tell you why I think that was the case. They believe in sexual slavery. They believe women should only have sex for free. They believe she should have no choice in the matter. Male sex workers ditto. A woman selling sex was seen by them as a victim, even if she was fully independent. So she would not face charges, but while she was selling sex, anyone protecting her, being her landlord, doing her taxes, advertising for her, babysitting her children, paying her rent, loaning her money, keeping her as a mistress, they would be charged. But wait, it gets worse. In the hearings, Mr. McKay, Mr. Nicholson's successor as Justice Minister, another piece of work, said there was no reason to refer the new bill to the courts to see if it was constitutional. When asked what acts were deemed illegal under the Act and which, like those of a dominatrix, might not be, the jerk said the courts would have to decide. I'm being kind to him. His legislation is probably void for vagueness alone, if I read the Supreme Court decision correctly. So another takeaway is this. When a government tries to tell consenting adults what they can and can't do in private, they should be opposed. The Liberals, who were in opposition in 2014, voted against that legislation and promised to repeal if elected. They were elected. The repeal has not happened yet. But there's no widespread outcry. That's because enforcement of the present law is minimal. And the sex trade and everything around it is booming. The government is happy to avoid the controversy that would accompany full legalization of the sex trade. Sex workers, there by choice, don't see an urgency for new legislation, since it would involve licensing and registration burdens and whatnot. But some sex workers are not content. Human trafficking is flourishing under the new laws. We warned about that. In 2014, the 2014 law encourages sex work to be more underground. If the sex trade was fully legalized, there would still be human trafficking, but clients would know whether they were attending a licensed business and would have no fear of facing charges if they reported suspected abuse of women. Landlords and hotels would be more willing to report and less willing to look the other way when laws were broken, because they could make money from the sex trade without breaking the law. Sex trade workers obeying the law could reduce competition by reporting violators. Police could concentrate on more serious matters than making sure women are only having sex for free. In the hearings during Bedford versus Canada, it was proven that other countries found what I said to be true. Organized crime and human trafficking did not go away, but that is the case with any activity. For example, there are sweatshops, illegal nannies and whatnot, and you can be sure those women are being abused there as well. You get the idea. You don't have to be in the Canadian Armed Forces under Peter McKay or the RCMP under Vic Taves to be sexually harassed women, although it helped. Under that law, under a law and order government with stiffer and mandatory minimum sentences. But enough about Harper and his trade seals. Mr. Trudeau and his Justice Minister, Jody Raybould Wilson, now have a chance to differentiate themselves from Harper, Nicholson, and McKay on these issues. As I said, there's no pressure on them to hurry. Also, the interrelated issues are complex and time is needed. The controversy, no matter what they do or don't do, is going to be intense. Look at the marijuana reform. That came over a decade after it was, I read somewhere, Canada's third largest export crop. I don't know what the monetary value of the sex trade is or was, but it ain't peanuts. I hope you remember going forward that as law students and then as lawyers or lawyer graduates, you will have more ability and more opportunity than most people when it comes to defining our rights and freedoms. I have seen law students in action in my legal battles. I have seen the lawyers. I have seen the activists. I have seen the media. I have seen the voters. I have seen the criminals. I have seen my immediate supporters. No shortage of villains. No shortage of heroes. I hope you have the privilege of a role when the debate of the sex trade begins again. Thank you for having me.